Thank you very much. Mr. Samuel, you can switch your mic.
May I
You can
be
switch it
allowed?
on.
Okay.
Thank you. Honorable Peters, I now recognize you.
Thank you very much, Chairperson. Before I continue with my questioning, may I be allowed to switch off my video?
We now can see you. Now you can switch it off.
Thank you, Chair. Thank you very much, Chairperson, and good day, honorable members, as well as Ndate Samuel. Thank you very much for availing yourself to the committee. And Ndate Samuel, my question is, with regard to your concern about the high budget for legal fees, which during the 2019-2020 period was 10 million. You further characterize this as a reckless litigation in your evidence in chief. Would you say this is indicative of a public protector who did foresee litigation because she knew her conduct was reckless and did this deliberately?
So I would like to ask that the question be repeated. There's a part I missed, I could not hear, especially where the question starts. The background I heard.
Okay. Repeat your question, Ausdipur.
In paragraph 5.3 of his Mr. Samuel's affidavit, he expressed concern about the high budget for legal fees, which during the 2019-20 financial year was 10 million. And you further characterize this as reckless litigation in your evidence in chief. My question to you is, would you say this is indicative of a public protector that could foresee that litigation was going to be a major budget item because she knew that her conduct was reckless and did this deliberately?
Yes, thank you, Honorable Member. Based on my earlier evidence that when one considers whether or not to litigate, there are many factors to take into account. And certainly the cost attached to that litigation is a huge factor to consider, especially in relation to what, to giving consideration to your insufficient budget generally as an office, and the main mandate of the office, which is not to litigate. So I think the failure to take those considerations and the chances of success and so on would in my books amount to that reckless litigation.
You also expressed concern that the budget was overspent with about 17 million. I just want to know whether in the previous period, the previous public protectors or the public protector office never had a situation where they overspent the allocated budget for litigation.
Yes, that is so. We never had to. There was an amount budgeted, but very, very less, even less than 10 million. But we had definitely not exceeded that at any stage.
Still on a financial matter, Ndate Samuel, why do you believe that the roadshows that the public protector undertook were useless and fruitless?
I cannot say that they were useless and fruitless. I think it is necessary that the public protector, as the executive head of the institution, should be seen, not only be known or about or seen on TV, should actually be seen live by stakeholders that are important to us, as in members of the public, especially, and politicians. I have no issue with that. I think it is necessary to engage with those stakeholders. So it would not be fruitless in my books.
Okay. My next question, Chairperson, is, Mr. Samuel, you bemoaned the fact that investigators had been confined to the office and operating without vehicles. Do you think that this was done deliberately to weaken the office? Or can it genuinely be regarded as an office that was underfunded and lacked resources?
We have always, throughout the years, certainly throughout all the public protectors, we have always maintained that our budget is insufficient. But there are other factors that make it insufficient. And with every advance we made to Treasury or elsewhere to increase our budget, we had resistance, generally told to make do with what we have. And so engaging in litigation in our books took a huge chunk of what we would have had to expend elsewhere in the pursuit of our mandate than was necessary. I hope I've answered the question.
You did answer me, Mr. Samuel. And that is, Samuel, you gave evidence that the public protector did not want any findings against politicians. And further considering the removal of the findings against the then Premier of the Free State and the then MEC Zwane, that is the Premier Mahashule and MEC Zwane of maladministration, which you made in the revised draft report. Do you believe through this that she tried by all means to protect politicians at the expense of the public?
Yes, I do.
And considering your allegation on how adamant the public protector was of exonerating politicians, would you now say in hindsight, she was influenced by them?
I cannot state that as a fact. I'm not aware of her, of them putting pressure on her. I'm just surmising from the fact that she wanted those findings removed, especially under circumstances that happened after she had met with them. It led me, and it's still my belief, that she sought to protect them. But as a direct fact of them saying to her that they must not, she must not find against them, I cannot state that as a fact. But her conduct certainly suggested that she was protecting them.
Samuel, in paragraph 26.5 of your main affidavit, with regard to the Financial Sector Conduct Authority report, you indicate that the public protector had agreed that the report should be set aside. Did you inquire from the public protector why she decided otherwise?
No, I did not. No.
Or did you raise your concern in relation to the previous issues, the frivolous and vexatious litigation that led to the soaring costs of the Public Protector of South Africa office?
Not with her, but I did raise them with, in the management meetings when I noticed that we were incurring more and more and higher expenses in terms of litigation.
Okay. And did you at any time, Dr. Samuel, during the period when the public protector abolished the think tank, suggest that this not be done, considering the important role that you said and the previous witness said it played in ensuring the reports are beyond reproach?
No, I did not. I must state that even throughout the time that the public protector has been in office, she has always maintained a buffer between us in the provinces and herself. She would communicate to us directly only through emails if she wanted to, but generally she would approach the executive managers, and then the executive managers would be the ones communicating with us about whatever she wants. So directly, I've never done that because that door was never open.
Okay. With regard to the reference to the Freda Farm inflated prices of the gate, and the basic structures of the guardhouse, the cows and milking parlor, you give an indication that in your view, the pictures of the gate indicate that the 2.6 million spent on the security gate and the guardhouses is not of market value. In your view, it could have been something like 50,000 rand. You also say that the 30 million spent on milking parlor, it's supposed to be around 7.2 million. And you say what was spent of 6.2 million on cows actually gives you a picture of the 3.4 that it could be. I just want to know from you, you say the pictures were missing from the report, and yet they were there in the April 2017 report. Did you raise this issue with the public protector?
No, I did not.
Do you think she was aware that the prices were inflated?
And that will be your last question. Go ahead.
It's a follow-up, Chair.
Okay. Please go ahead.
I wanted to know whether he thinks that Mr. Samuel thinks that she was aware of the price, that the prices were inflated. And that he thinks that she consciously and deliberately removed the matter of the cost of these items from the final report to water down the report.
I did not know that. I do not know that as a fact that she knew that they were inflated. But my view is that anyone seeing those pictures, and with me having been there and seeing the actual structures, especially of the gate and the guardhouse, I'm making that assessment, and she was there as well, when we did the inspection. To anyone, any reasonable person who perhaps has a house or some kind of investment in terms of building, you can make an assessment that this is not worth that amount. It's certainly, there's nothing special. It's a manually operated gate made out of a devil's fork irons, and even the 50,000 rands that we kept it at it might be proven if we thought of getting quotations, might have been proven to be exaggerated or perhaps even lesser. But certainly with the other items like the milking parlor and so on, we got that information from the Cattle Breeders Association. And we had no reason to doubt their bona fides about what they place, the value they placed. But to be direct, even with that one, I wouldn't know whether the public protector would make that finding. My consideration and hers might be different, but if there was an issue, it should have been at least taken up with us who were making this finding in the report.
Thank you.
Thank you, Chair.
Thank you.
Thank you, Chair,
Thank you,
and Mr.
Peters.
Samuel.
Thank you. And I recognize Honorable Maute.
Thank you very much, Chair. Good afternoon to your good self and the members of the committee, the public protector and her team, and the witness. Mr. Samuel, I think this question has been asked, but maybe differently. But for the record, I would like to post it to you. And I'll appreciate if you could respond to it. Did you write the affidavit yourself? Because you mentioned that you have not read many of the judgments against the PP, but you made reference to them in your affidavit. So how is it possible that you write and cite something that you don't know about, that you have not read about?
Chair, I did not, I'm struggling to hear this honorable member, but I believe the question is whether or not I drafted the affidavit myself. The initial one, yes, but the second one, I did not draft it myself. It was drafted, as I said, my belief is that it was drafted because he's the person that I was interacting with, by the assistant to the evidence leaders, based on the information that I had given them and what they had retrieved. The draft was sent to me to look and read through. I did that over 2 days to satisfy and made some changes, yes, to the extent that it was drafted with my direction. I agree that physically it was not drafted by me, but it is my affidavit.
So I'm made to believe that you are a legal practitioner, a qualified lawyer for that matter. So yesterday you admitted that some points that you made in your statement, like the rules of the committee.
Just Honorable Maute, just reposition yourself, please, so that you can, there seems to be a bit of an echo there where you are. Maybe also come closer to the mic so you can hear you properly, and then start again on your second question.
Okay, can you hear me better now, Chair?
It's better now. Can you hear Mr. Samuel?
Yes, I can hear.
Okay, no, thank you, Chair. No, I was saying we are made to believe that Mr. Samuel is a legal practitioner and a qualified lawyer for that matter, who yesterday admitted that some points in the statement, in the affidavit, like quoting the rules of the committee, he has not read them. He has never read the rules. Now, are you not perjuring yourself, Mr. Samuel, by affixing your signatures to an affidavit whose contents you cannot fully vouch for? You just said now that the second affidavit, it was drafted in the assistance of the evidence leader, and you can't vouch for that fully. So are you not perjuring yourself?
No, I'm not.
How so? Because by signing an affidavit which gives specific details from judgments which you have never read, which could be misleading to the public and to the parliament, that should be viewed as perjury, isn't it?
I'm going to differ with you and dispute that I had never read the judgments. I did state that at the time they came out, I had read them. And the only thing that I had not done was, at the time the affidavit was drafted, I did not revisit the judgments. But for the fact that I referred to the comments, and that is all that I needed to confine myself to in the affidavit. It was the comments that were made by the judges, the scathing comments. If the rest of the judgment discussing it and was necessary to make my point, no, I don't consider it to have been necessary. It was not based on the whole judgment. It was based on the specific comments made, and those stand because they are public knowledge now.
So yesterday you said that when you're responding to the cross-examination, you said that your affidavit is made up of your own recollection of events and from the emails extracted by the evidence leader from the PP server. Now, based on the fact that you were fed this information, particularly on the second affidavit by evidence leaders, don't you think it somehow compromises your reliability as a witness?
No, I don't think so. And I denied that I was fed that information.
How do you explain your earlier response of saying that it was deposed by the evidence leaders? You just went through it and checked it for yourself. How do you reconcile that?
It was prepared for me based on the information that I'd given, and there is nothing wrong with that. I don't know how much of practice you know, but in any situation, even for myself as an attorney, if I'm involved in any proceedings where an affidavit would be required of me, it would be prepared by my attorneys, by my lawyers or advocate. It is perfectly, because they know what needs to be zoomed into, and by my direction, it was to go into those comments. If perhaps that is viewed by anyone to be perjury, I'm open to having it tested, to the extent that if I'm alleged to have perjured myself, let's test that in the court.
Yeah, no, the testing will be done not by me, but by people like you, and I'm sure they will come to some sort of conclusion. But so let's pass on that one. You mentioned that you didn't like Advocate Mkhwebane's management style. Is that the reason why you felt the way you felt, such that you even wrote to the speaker because you didn't like Advocate Mkhwebane's management style? And as such, she must then be taken through the process of impeachment.
Could you please repeat the first part of your question? I didn't hear what you are saying. I did not like about public
leadership style.
Oh, leadership style. Yes, I did not like it. Sorry. I did not like it, but that is not a reason for me being here, or maybe mentioning it in my affidavit. That was not the intention of having her impeached. I do make the point that, in my opinion, and to the extent that it is stated in my affidavit, the initial affidavit, I do not regard her as fit to run that office. But that is not the same as saying that she must be impeached. That was certainly not my intention or the purpose of me deposing to that affidavit. That is a determination that will and should be made by the committee of which you are a member, and you will then put whatever value put to it, like every other member.
Yeah, so earlier on you testified that you are one of those who supported her when she was in the run for the PP office. And then it's only after being appointed that you started having issues with her. Am I correct? That is correct, yes. Yeah, so when you just said now that, earlier on you said you didn't have a problem with her leadership style. How is that? When did you realize that? Is it after she was appointed, and what caused you to then have second thoughts about her leadership style that you vouched for and you encouraged during the running of the interviews for the PP office? What has changed?
Honorable Mauto, you misunderstood me. I said when she was interviewed, I I thought she did very well, and I used the word she aced the interview. That had nothing to do with her leadership style. It was questions posed to her like as it was done to every other candidate, and it had, her leadership had not started of the institution. It only started thereafter. So that is why I then thereafter, when she was involved in the leadership of the office, that my opinion changed. But at the time that she was appointed, it had nothing to do with her leadership style. It was not apparent at that time.
Okay, I won't push you further on that one. That's fine in the interest of time. Now, Chair, Mr. Samuel mentioned that Advocate Mkhwebane engaged in reckless litigation because she insisted on defending reviews against her reports, as if it is not in the best interest of the public that the PP serves to defend against entities that may have caused harm to the very public. Now, why do you, Mr. Samuel, view that as reckless litigation? What made you to think that that's a reckless action by the PP?
Chairperson, I think I've answered this question more than once, on a number of occasions. And I've stated that I formulated that view based on the fact that some of this litigation was not necessary for the office to be engaged in. It was ill-considered, in that the prospects of whether or not we were going to succeed was not taken into account, and the amount of money that was going to be expended pursuing that litigation was not considered, was completely ignored, and so the budget was then diverted to finance that litigation. For me, that is reckless.
So, have you practiced before, Mr. Samuel? Have you stood in court and took a case to court and won it or lost it?
Yes, I have.
And have you felt that some of the cases that you've lost, you might want to pursue them still?
Yes, I have.
And that was your
So
sole...
I don't understand when you say still, but at the time, yes, some I did pursue, yes.
And that would have been your decision, right? Guided by whoever is around you, like your legal counsel or whoever is around you. Isn't it correct?
That is correct.
So why do you see it being wrong when it's done by the PP? When she received some advice, which she felt that very strongly that she can challenge and litigate, why should it be your problem? Because you are not the PP, and at the time the PP felt that it was correct for her to do so.
Chair, we are an institution of integrity that investigates and finds similar conduct against either departments or other officials. We hold them to a standard that we ourselves need to be to also uphold, and so it would be unprofessional or unreasonable of me when I can make that determination and put it in my report for final signature by the public protector, that I cannot allow a situation where we also need to be held to that standard. The fact that a person is in a position of authority to make a particular decision does not mean that he or she must make it recklessly without regard to the fact that what we're spending here is public funds, and we need to account for those.
Your last question.
Yeah, my last question would be, Chair, it's on the issue of the party. Is there anywhere in the laws of this country that dictates who the PP can invite to the party and not invite to the party?
No, there isn't.
Okay, thank you, Chair. That's all.
Thank you, Honorable Maute. I now recognize Honorable Skosana.
No, thank you very much, Chair, and good afternoon to everybody. Yeah, Mr. Samuel, yesterday when you responded to Advocate Mpofu during cross-examination, he asked you whether you read the independent panel's report, and you responded by saying you didn't. My question is it not strange that as an aggrieved person who had by that time already launched or filed his affidavit with the Honorable Speaker of the National Assembly regarding your request perhaps to get an investigation done in the Office of the Public Protector. Though your intention, like you said, was not about the issue of impeachment and so forth, but your intention it was to get an investigation done in the Office of the PP. But now here is a process is initiated by Parliament of appointing an independent panel, and that independent panel issued a report. So is it not strange that you did not read that particular report?
Me at the time, and I would go as far as saying even now, there's nothing strange if I did not have any interest in that report, because I did not send my as you say, you know, in my response, I said I did not lodge this request with a view to impeachment. For me, that concerned impeachment and nothing else. I got to learn that my affidavit, you know, also served there, and I was only interested in knowing what was said about my affidavit. I did not have to read the whole report to know what was said about my affidavit. So I did not have that interest.
Okay. Yeah, the next question in paragraph 19 of your second affidavit, the one that is before us, you unpack the general operating processes of the Office of the PP, and you specifically indicate at paragraph 19, at subparagraph 19.6, that if circumstances warrant, the PP considers and signs off reports. So the question is, under what circumstances do this normally happen?
Normally under circumstances where we make, you know, we investigated or we classified the report as high profile, for whatever reason, either it involves politicians or it's a tender matter, or, you know, irregularities in the awarding or you know, of the tender or payments made, and that leads to formal reports. So those were, you know, those are the reports that she signs off, and some of the reports that she also signs at head office are closing reports. I made reference to that, but that part was also delegated to us in the provinces, to the provincial representative to sign off. So that is what that covers. That there are specific reports that have to be signed by her, but not all of them. So it depends on the classification of the report.
All right. Now the next question, do you know whether the PP ever took internal advice on whether to defend some of the reports that were set aside in court? This is in reference to the point you made in paragraph 26.1.1.
The question is, do I know whether she took internal advice? No, I do not. That advice would most probably come from the senior manager for legal services. But from and maybe from other managers, especially those that are involved or that would have been involved in that particular report. But I'm not aware that she was given advice or she asked for it.
So there were no discussions whether at management level or at whatever structure where these things are discussed before a decision could be taken whether to take such a decision.
Not that I'm aware of. I cannot say that there were discussions around this. I was not part of them, so I wouldn't know.
Okay. Now the next question is, during your interaction with the officials from the Premier's office, by the time they conveyed the message from the Premier about his request to meet with the PP, did you ask them why your own previous request to meet with the Premier had not received a courtesy of a response?
No, I did not.
Why not?
These were officials that were far removed from the Premier, so I did not. It never crossed my mind to ask them, and the reason why it would never have crossed my mind is because they were only assigned to work with our office for the preparation of the stakeholder engagement. So these are not officials that, even if I had thought of it at the time, that I could have asked that question and gotten an answer for. It never crossed my mind.
So after the Premier met with the PP, you made mention that the Premier came out and then spoke to the CEO and ignored you. So what could be the reason?
I don't know. I have my own suspicions why. I think it was just his continued decision not to recognize me and my role in the office and engaging. I can't think of anything. I don't know why he ignored me. But he went straight to the CEO, introduced himself, and then turned around and walked away.
Okay. The next question, I think under subparagraph, paragraph 26 and subparagraph 26.1.6, you said that in the High Court, the OPP had been represented by Motswening Bill Attorneys Incorporated and 5 councils. And in the Concord, this team was replaced in its entirety. The new attorneys were Shuttle, Thompson, and Hyson Incorporated, and new councils. And then you go further to say this substitution of the entire legal team for purposes of the appeal would have significantly increased the cost of the process, as each new lawyers would have had to acquaint themselves with all of the material on record. So the question is it the PP who made these changes or who issued the instruction for such changes to be made?
The decision as to which counsel or which firm of attorneys is appointed in any particular litigation involving the office is that of the PP. And my point in making, in saying what I'm saying there is that attorneys and advocates charge either by the hour or for the day, for the time spent on any particular matter, and reading, acquainting yourself with the record and reading documents that you are not involved in to bring yourself up to speed about what the issues are and how you challenge it necessarily means that you're going to pay more for that person to be up to speed with what was in the case and be able to give you advice on whether you proceed or not. Unlike it continuing with the same team, which would be up to speed with the the issues. From the cost point of view, it is for me ill-considered. Unless there's a total breakdown between you and the team, it might then justify for you to go with another team.
Okay, no, I get you. But then are there no procurement procedures that give guidance about the procurement procurement processes of legal services? Is it just a one person's decision?
We do have procurement procedures and processes and a process to follow, but I am not aware of it being applicable to legal services. Generally, if it does happen, because I've never been involved in initiating a process where we have to get legal services, as in doing a motivation and then making a requisition to start the procurement process. No, I've never done that. I don't know at head office whether they do that, because that is where those decisions are taken. But I'm not aware of them falling within the procurement process. I'm not aware of it, so it might be that it happens that way, but I'm not aware of it.
Okay.
Your last question.
Yeah, I wanted to say this before the chair says. Okay, yeah, in paragraph number 87, where I think that's where you speak about the think tank. You say that at the very least, the OPP should have attempted to hold the think tank sessions visually, which would have allowed the important quality assurance function to be retained without the associated traveling and accommodation costs. So the question is, did you make this suggestion to the PP and the management team? If yes, what was their response? If no, why not?
No, I did not on both, to both the PP and the management team. I accepted that it was a decision that was taken, and so I did not question it. But my point is that if the most compelling reason for the abolition of the think tank was the cost factor, then at least alternatives should have been considered and perhaps tried, which is why I'm saying, just like the management meetings went on virtually, that could also have been explored.
Thank you. The last two names, Honorable Maneli and Honorable Lotrit. Honorable Maneli.
Thank you, Chair.
Honorable Maneli.
Thank you, Chair. In case I experience a network, because earlier on I was having an unstable network, I'll then switch off.
Thank you.
Chair, as the first point to raise, so that I know if I'll have to still pursue these questions later on. Maybe just from the evidence leader, I just need a confirmation that as part of the witnesses to be called in, whether so referred to Nemasisi and though more frequently in the witnesses that have come before us, if they are also meant to come before us. May I just check that, Chair?
We had provided the witness, we had in mind a witness list, and he was at the time a senior legal manager. He's not in the employ of the Public Protector's Office any longer, and he was disinclined to want to provide us with assistance. So he's not on the list, and if the committee wishes to hear from him, then we would need to take steps to pursue that.
Okay, thank you. You got that, Honorable Maneli?
I've got it, Chair. I think we'll come back to it at some point. Just for purposes of ease of reference, in terms of questions, I'll be focusing in the main on 182 to 184. But just firstly, to cover the point, to clear my understanding, as I greet you, Mr. Samuel.
Good afternoon, Honorable Member.
Good afternoon. So I just want to check again, just to confirm what you've raised, if I picked it properly. You are saying that with regard to the removal of the politicians, this would have been direct to you, not because you got it maybe from somewhere else, or am I mistakenly thinking that that's what you said?
Yes, it was said to me.
Okay, thank you. With regard to the subpoenas that you wanted, as it relates to these politicians responding to what you would have put before them, were these in writing to the protector? The permission to
I would have
subpoena?
had to prepare those questions. Sorry, you still proceeding?
No, I was just saying the permission, where you asked the permission to subpoena the said politicians to respond to yourself. Were those in writing, the people?
I did have questions that I had posed to the that they would have posed to the politicians, but when requesting a subpoena, especially for witnesses that are politicians and some maybe who are above like DGs and so on, I mean who are below like DGs or MECs. The reason why that the directive was that subpoena must be signed by the public protector, and that is because that official or that member has to appear in terms of our act in front of the public protector. The only part that was delegated to us was lower officials, so they would have had to appear in front of the public protector in Pretoria, and if they were appearing because they were subpoenaed, and it was my investigation as it was in this one, I would also have had to either be there or send questions about what I want them to respond to, either to someone who will represent me there, like my line manager, because he would be at head office. But the long and short is that I would have had to prepare those questions, and that is how we have always done that.
Now, Chair, I've heard with regard to preparing questions. What I'm asking is that needed to be signed by the public protector, which is the subpoena.
Yes.
Was that done in writing to the public protector from yourself? And surely the question then that follows would be, if it was declined, whether there was a response in writing there too, with reasons.
Oh, no, I had not prepared the subpoena at that time. The subpoena is generally a draft document. We already have it. It's just a cut, we type in the names of the official that you want to be subpoenaed. I did not present the subpoenas, the drafts, to the public protector. I first spoke to her about them. And when she declined, there was no need for me to then send the subpoenas because I knew she was not going to. She had made it clear she was not going to sign them.
Okay, so that's clear, Chair. Just to follow up that question still on the politicians. One of the emails that was flighted, there was an indication about Section 7, subsection 9, that the public protector needed to sign, and she would have indicated that it did not take into account the responses received from the Premier. So would you say those responses were responses to that you would have prepared and sent for response from the Premier's side?
Are you referring to the Section 7(9)s, the notices?
Yes, yes, I'm saying that, Chair, to you, so that I'm clear. The point I'm making is that there was an email where the public protector would have been concerned, in my view, about having to sign such, but there is no indication of the responses that would have been received from the Premier's side. And my question, therefore, about responses in particular, it's whether these are the responses on the basis of what you would have prepared as questions that they needed to respond to from a point of investigation.
No, the Section 7(9)s are not a process whereby we seek information as part of an investigation. It is a process that follows when we consider that our investigation is nearing an end and we are likely to make these findings against the implicated person. In this case, the Premier, for instance, as you asked, or any other party. If we are going to be making adverse findings against them, that is why we then issue a subpoena. And then, we in that notice, we state what the complaint was and everything, and what the evidence we have is, and what the law says in relation to the conduct complained of. And based on that, what is likely to be our finding, and we invite them to then say whether or not they agree, and if they don't, to provide us with information to rebut what we're saying in the letter. So the information that I would have wanted to be in that was one that was excluded by the fact that at that time, it was not open for me to ask the questions that would have informed them that we are going to make a particular finding against them. They had not participated in the investigation.
No, thanks, Chair. I understand it exactly as you explain it, and this is why I have this question. The responses so referred to that are not included as part of completing your report that the PP referred to on the email that was flighted by the evidence leader in trying to get more information. I'm asking whether those responses that the PP refers to were in relation to the questions that you would have asked and as you say, were not responded to, or if not, which responses was the PP referring to that could have been obtained from the Premier?
Those responses did not include or were not in relation to the questions I would have asked. They were based on the available information that they had not been confronted with. So they would only, have to respond to that, to the questions I would have asked if I had asked them and they responded, and they then led to our draft, which we wanted to confront them with in the section 7.9.
So in essence, you are saying by the time you got to that part of the report, still there were no responses in relation to questions that they needed to be responding to as confronted by the office. Am I getting it right?
I'm not sure which what I've tried to explain, and it doesn't look like the honorable member understands what I was, the process I was explaining. In the section 7.9,
You have a chance to make him.
Yes.
I'm trying. In the section 7.9 notice, I did not ask questions of, inviting them to respond to. The section 7.9 relates to possible findings based on the evidence we have as at that time. And it is not an opportunity to then ask them new questions. So I did not ask any questions that they would have had to respond to in the section 7.9.
Okay, Chair. All I wanted to get then is confirmation that the questions that he confronted the office with, which its responses would have formed part of this draft report he refers to. Therefore, when the PP says responses that were not included, these did not talk to the questions that were never responded to up until that stage of the report. That's all I wanted confirmed, because then the next question could still be what was the basis of finalization of the report. So if we agree on that, I would want to leave it and get to the 182. I didn't say you should have asked questions at that stage. You are on a report, they may be implicated in a way as you finalize the report, but you still had questions that were never responded to. That's what I wanted to get. And then I can move Chair to the next point.
Please move.
So in the next point, I just again wanted to just check your concern with regard to 183, where you also show pictures of whether it's the entrance gate and so on, that in the final report, these were excluded from the report. And looking at what you raise materially about money spent, whether wasteful or not, I just want again to check there that necessarily the point you are raising, and I want to be sure if I get you well, is that you are raising a point here that the PP in finalizing this report would have presented a report that conceals information, and this would have been deliberate, given that it was already in the report.
The removal of those pictures amounted to concealment of the evidence regarding the evidence upon which we made a finding that the money spent on those structures did not justify those structures, did not justify the expenditure. It would leave a person reading the report with an incomplete picture of what we're talking about. That is why we included them there. But being removed amounted to, yes, concealment.
That's my third last question, Chair. On 184.
The last question, can you?
Third last question.
I didn't get that. You said your second last question.
No, I said the third last question, Chair, because I said 184 up to 183. But I'll stop when the Chair stops me. Chair, on 184, again, I want to establish again that you are saying there, you are talking about the report that says there was inability to investigate certain issues, and you quote, due to capacity and financial constraints. In your oral evidence, you would have indicated that you disagreed with this on the basis that there were experts readily available for free, and therefore inadequate capacity would not be an issue in financial constraints. Again, I want to check here. Would you say that the public protector would have deliberately misled society on this, in that those would have not been applicable, and therefore even the need for further forensic investigation would not arise? So are you also saying that's a sense of dishonesty or misleading in that score?
Honorable member, if that was my view, I would have stated it, I believe, in that paragraph. But that is not what I'm saying. What I'm saying is that we did not need experts. We did not need to have to spend money to acquire experts that would tell us what we could get for free. And we did. That's why we spoke to people that we consider, or organizations that we consider to be experts, like on the milking parlor. So that reference there, that we did not investigate certain issues due to capacity and financial constraints, was for me misleading.
Okay, no, thanks, Chair. That is responded to that. It is misleading. I just want to get two questions on the legal fees, but again, is to just understand this point. On that page 2150, I think the evidence leader also showed us the financial statements. May I just check on that one? Why would the legal fees be separated from consultants and professional fees, which in other financial statements would have been put the same? So I'm just raising this from a person who just reads the statement without knowing, because when I look at the numbers, the legal fees will show less than $1 million, but when you get to
he got the question. Let him respond so that you don't prolong it.
Okay, thank you.
That, the clubbing legal fees under that general heading was a departure from the way that the report was previously prepared with regard to legal expenses. And there was, in my opinion, no reason why it should have been separated. I believe the fact that the committee, or maybe the portfolio committee, asked the questions specifically with regard to legal fees, answers the very question that, had they been specified to be legal fees in those reports, it would not have necessitated that question being asked of the office and to respond thereto. So it was also, in my view, a way of concealing the exact extent of the legal fees, and not breaking it down either by reference, maybe as a footnote or something, amounted to to concealing that information, and hope that I'm not going to be asked about this. For me, that is how I view it.
As I said, the last question, Chair, is on just a positive thing about the public protector.
Must be brief, Honorable Bailey.
Yes, I'll be brief, Chair. It's just that I want to be clear on the notes I've taken. The entity, the think tank was, as you described, more of also an opportunity for peer review and then learn from others. And I want to raise the other point as a positive point, that the public protector got to be interested in every case. Like you were saying, you had to populate every week, but also that there's been introduction of accountability, responsibility in the assurance side of things, quality assurance, that you take personal responsibility at your level, at the level of the middle, but also the public protector. I want to just ask the question, will you not see this as something positive, especially with all the problems you've raised, where there can be personal responsibility at different levels, including the public protector not able to say, I'm exonerated on any decision because she or he would have at least had an opportunity of ensuring quality assurance, and therefore will take personal responsibility like any of the other people that have signed off on the report. So I just wanted to check why.
Thank you, Honorable Bailey.
I agree that it was a positive development, particularly seen in the light of the value chain of the investigator responsible for the investigation, all the way up to and including the public protector. It meant there are more people, making sure that things are in order with a particular report. I don't have an issue with that one.
Thank you. Honorable Latridge.
Thank you, Chairperson. I'll be very brief. Good afternoon, Mr. Samuel.
Good
I just want to go back to the whole Section 79 letters and the responses in 161, paragraph 161 of your affidavit. You state that the NEC and the accounting officer also submitted responses around that time. As far as I recall, these responses were submitted to Advocate Nkubani and the OPP head office. Did you ever have sight of any of the responses from any of those Section 79 letters that were issued?
I cannot with certainty say that I had sight. I might have, because ordinarily the practice would be that because the letters are signed by the public protector, and so they would emanate, they would be on the letterhead of the private office. Even though my name might be cited there as the person to make inquiries to, if the report emanates from me. When the private office receives the responses, they would invariably send it to the originating office. So I might have seen it. I cannot exclude the fact that I might have seen it, but what I note there is that it was on the 14th of July. I might have seen it later on because I was on sick leave then following an operation.
Thank you. And then just a bit further down, you referred to in 163 about the investigation file that had to be handed over to the head office. Was this normal practice that a whole file of an investigation be handed over?
That was not the practice. Initially, it started off with the evidence upon which we base our finding, and would have to be sent, and we make copies, not send the whole file. The file would still be kept because it was a file of the Free State, so it had to be there until finality. So this was not normal practice; it was something new.
Was any reason provided why it should be sent to head office?
No, none.
Okay. Now, Mr. Samuel, you said that in your affidavit that on the 4th of July 2020, and you said that was actually the date that was you could resume your duties at the office after the CCMA award.
Oh, yes.
Have you resumed office?
Yes, I have. The award says I must report to, for duty I have, and I've been going to work every day until last week Friday, and I only came, it's only this week that I have not been there since I've been here.
Okay, and when you were suspended, you also had to hand in your laptop.
Correct, yes.
Have you been reissued with your laptop with all your correspondence on it that you had before?
No, in the affidavit, I state that that laptop could not be traced when the evidence leaders contacted the office. And so I'm not in possession of a laptop as I'm sitting here. I have not been provided with one. I did ask for it from head office, but I was told that they are still considering the award and would come back to me.
Okay. Are they considering the award?
Yes, they were saying that they were still studying the award and considering their options.
Okay. Thank you. And then just lastly, we referred earlier to the security clearance, and that you said that it was not common practice that everyone had to get security clearance in the previous under the previous public protectors. Is there anywhere in the Public Protector Act or in the Public Protector policies that makes that a requirement?
No, to my recollection, not in the Act. I'm not sure of the policies, but I know that, the practice now is with every advert that is placed, of any post, particularly say, of investigators and so on, that is put as a requirement that candidates would have to undergo that or to provide that. Yeah.
And according to your understanding, where would that derive from, that requirement?
It was, all I can say is that it was first introduced by Advocate Enquiry when she came in, but as to what the reasons are, I don't know. I do accept that where we would have to deal with classified information or documents, it is necessary to have that. But up until then, in fact, even as I'm sitting here, I have never had to deal with classified documents, and a lot of my colleagues as well. I do know that, from some of the colleagues that came in later on during the years, they would come and showing that they have the security clearance, which I think would last for something like 10 years. And so because it was now a requirement, they would have met the requirement. But for us who had been there earlier and throughout this, it was never a requirement.
Thank you very much. Thank you, Chairperson.
Thank you.
Thank you, Honorable Lotrit. Thank you, Mr. Samuel. For today, that's where we end with you. The evidence leader will probably be in touch with you together with Advocate Mpofu about the conclusion of the cross-examination, which could be virtual. Anything as you leave you want to say?
No, I just wanted to thank the committee, for the invitation and the cordial manner that I was treated here. Thank you.
Why are you smiling when you say cordial?
Because it's a positive feeling that I have that it was cordial in general, Chair. Thank you.
Okay. Thank you, Mr. Samuel. We'll take a 15 minutes tea break, early tea break, and be back at past to interact with Mr. Hassan Ibrahim. Thank you. It's work.
Recording stopped.
I feel like Friday. 15 minutes break. Thank you. uitgevang. Honorable Dlagode. Honorable Majosi,
I'm here,
are you
Chairperson.
there?
I am here, Chair.
Thank you. Welcome back. Let's resume. Let me take this opportunity and welcome you back, Mr. Hassan Ibrahim. Welcome back.
Thank you very much, sir.
You, just to remind you that you're still under oath, so we're not going to redo that process. And for that, we'll kick straight and without wasting any time, I am going to recognize Advocate Mpofu to interact with you.
Thank you, Chairperson. Good afternoon, comrade. How are you?
You can switch on your mic. Thank you.
Very well, thank you, sir.
Thanks. Yeah. Okay. Are you still a member of the ANC?
No,
Did you resign? Did you resign or join another party?
neither. It lapsed once I went into public service.
I see. All right. I think where we left it last time, I was busy dealing with you on the issue of the overlap between, let's call it separation of powers, but I think you were not understanding what I was saying, so I'm just going to try and explain it. I was exploring with you the uniqueness in the Section 194 process from a point of view of separation of powers. And given the novelty of this process and some of the complexities that we hope that the members will be able to appreciate. And the question I was putting to you was, or rather asking you for a comment as a person who knows anything about the Constitution, is maybe so that you can say what needs to be navigated. The fact that in this process, you know for a fact that the Constitution says the public protector will account only to the National Assembly.
Yes.
Okay, that's common cause. And yet, we have a situation where a member of the executive, a separate arm of government called the president, is given the powers to suspend, among other things. Okay, that power to suspend is directly dependent on the work of this committee. Constitutionally, if you read 194(3)(a), okay? In other words, if this committee does not do certain things, and our version will be that that's another topic which I'll come to now. For now, assume that we're talking about this committee. Or rather, let's say it's dependent on a committee of the National Assembly, to put it neutrally. So that's the first overlap, okay, which is an overlap that is legislated, for lack of a better word, in the Constitution. Now, in this particular process of Advocate Mkhwebane, that matter is further complicated by the fact that, according to some of the members here, effectively, all they need to do is just to take court judgments and that's it. Which that then introduces a further complication, which is that what we would be doing if we did that would be to outsource the accountability function of Parliament to the judiciary. If you see what I mean, that makes it even more complicated, which means now we would be having the National Assembly triggering action from the executive and then relying on judgments of the judiciary, which really means it would be the judiciary impeaching the public protector. How is that complexity to be navigated? Firstly, to be appreciated, but secondly, to be navigated.
Chairperson, it's a complex set of questions, and let me see if I have understood it properly. There's a number of aspects to it. I asked myself this question, and to deal with it, I started off with the Constitution, then went to the legislation, and then went to the rules. And I discovered the following sequence. Firstly, it was in the 3rd of December 2019 that the National Assembly developed rules, setting out the process for the
Adopted rules.
adopted the rules.
Yeah.
For the removal of office bearers in institutions supporting constitutional democracy. It was a couple of months later that on the 21st of February, the Democratic Alliance then produced a tabled a motion to initiate the inquiry. Subsequently, what happened is that the Speaker then, acting in terms of Rule 129U, established an independent panel. The purpose was to conduct a preliminary investigation or assessment to determine whether the information available, based on the information available, whether there was a prima facie evidence showing that the public protector had committed misconduct and or was incompetent. So there was an attempt to establish a panel to establish that prima facie evidence. Of course, there were various court cases in between, but subsequently the panel then submitted its report on the 24th February. What the panel recommended was that the charges of incompetence and misconduct be referred to the committee. So the panel had undertaken an assessment or an investigation, interviewed or engaged with all the parties, including the public protector, and come up with. What then takes place is that the report is received served before the National Assembly on the 16th March 2021. And the National Assembly resolved to proceed with this inquiry. Now, when this committee was established, it was established specifically or with the objective, firstly, to assess the charges contained in the motion in order to determine whether the public protector was incompetent and or had misconducted herself. Secondly, to report to the National Assembly on its findings and recommendations. So you had a set of rules in terms of which, firstly, the predetermination of what constituted misconduct and or incompetence was defined. Then a process set out, including the establishment of a panel and then the establishment of this committee to process the charges. There are different aspects to this that I want to deal with. The first is the predetermination of what would constitute a serious violation. Now, in the EFF case versus a Speaker in 2018, It very crisply set out really the requirement of the predetermination of what a serious violation was, which then prompted subsequently to 218, the rules that we currently have, which then defines really what misconduct and what incompetence would be, and defines the process. The second part to this is that we have then the panel report. And the panel report in its recommendations at paragraphs 260 and 261, having concluded it in its investigations, then made a recommendation to the National Assembly. And that National Assembly said, the recommendation said the National Assembly should, based on the findings, proceed with the charges. It was subsequent to that this committee was established. So the first point I wanted to establish in having tried to answer that question is that there's been much controversy and discussion around Section 194 and the committee established in terms of Section 194, whether the committee was to establish whether there was a cause or not. I'm saying very clearly that is not my understanding of how it should have been. In a sense, there was, in terms of the rules, a requirement that there should be a notice of motion which is substantiated with information and evidence attached to that notice of motion. After that notice of motion was received, the panel was established. The panel was established for purposes of establishing a prima facie case. Then only was this committee established. So the predetermination had already been defined in terms of the definition of the grounds. And so the committee is properly and duly constituted in terms of Section 194(1) to process as it states in its terms of reference to assess the charges contained in the motion. And in order to determine whether there was a case to be made for incompetence or misconduct, and to report on its findings. So that, in my opinion, was a properly constituted process, and the committee is therefore able to undertake its responsibilities in terms of Section 194(1). Now, it brings me then to the third part of it. I've dealt with the predetermination, I've dealt with the panel report. I want to deal with the last, which is the recent case in the Constitutional Court of the Speaker versus a public protector at, I think, paragraph 19.
Sorry.
It's your space.
Yeah. Thank you. I'm sorry.
You intervene when you.
Yes, when I feel that it's, yeah. No, I really didn't want to interrupt Mr. Ibrahim, but I don't want us to go back into this. We've covered this ground about predetermination and so on. My question was completely different. Yeah, I know he came here having prepared something concrete from after the last time. It's understandable. But if we can just confine it to my questions, Mr. Ibrahim, please, because also the other issue that people don't realize is that in cross-examination, you're sometimes guided by the witness. So you could take a whole hour answering the same question, and then the chairperson will tell me that I've finished my time when we haven't covered what I need. So if you can just be guided by my questions, I don't mind if you want to expand or refer to cases and so on, because that's the nature of the thing. But at the very least, let's start by answering the question. So we'll come to the EFF. I know you and I had a disagreement, which I see still persists, on what is meant by institutional predetermination. That's fine. I don't want us to go back there. I was simply saying that, hoping rather that you would assist the committee to navigate what I say is a very, very crucial gray area, even in my mind, around the interplay of the judiciary, the National Assembly, and the executive in the 194 process viewed as a whole. And it's quite a serious matter because, as I say, just by coincidence, it won't happen if maybe it's the Auditor General or whatever. But by coincidence, in this particular process, there is a desire to rely directly on judicial pronouncements, almost take a judgment and impeach, which in my estimation would then mean that it's actually the judiciary that's impeaching, and this committee, or rather the National Assembly, is just a conveyor belt. How should that be avoided, if you think it should be avoided? And how should the separation of powers issue be handled?
So frankly speaking, I don't see the same problem, and I'll explain why I don't see it in the same way. I'm not privy to how this committee has decided to go about its investigations. I don't know what choice of witnesses you have decided to call and who you have decided to call in terms of verifying this case. And I'm not sure whether you are relying strictly on judgments of court. So I cannot comment on that, but I want to say the following, that I don't think there is a problem in dealing with either the outsourcing, as it were, or a question or challenge to the separation of powers. In my opinion, having regard to the Constitution, legislation, and rules, the committee is a properly constituted committee to carry out its responsibilities without having to stray and violate that separation of powers, whether by absorbing or relying on court judgment. Having said that, I don't see any challenge to this committee having regard to those court judgments. And having said that, I want to refer to one specific court judgment which I spoke about, which is the Constitutional Court case of the Speaker versus the Public Protector earlier this year. In particular, I want to refer to paragraph 19. Now, paragraph 19 for me succinctly sets out the answer to what I think the problem is. And if I may read it, it says, the report of the independent panel must be considered by the National Assembly. If the National Assembly resolves that a Section 194 inquiry should be held, the matter must be referred to a committee established in terms of Rule 129AA, consisting of members of the National Assembly for a formal inquiry. The committee must ensure that the inquiry is conducted in a reasonable and procedurally fair manner. During the inquiry, the office bearer has a right to be heard in her or his defense and to be assisted by a legal practitioner or expert. However, such legal practitioner or expert may not participate in the proceedings of the committee. The committee must provide a report with its findings and recommendations, including reasons, therefore, to the National Assembly. If the report recommends that the office bearer must be removed, the removal must be put to the National Assembly to vote, and the requisite majority is achieved in accordance with Section 194(2) of the Constitution. The office bearer must be removed from office. In my mind, that paragraph 19 succinctly sets out really where we are and what the case is, and in my opinion, answers really the challenge and the question you are raising.
No, maybe before Advocate Mbofo comes in, just so that having done the prelude that you did, which was helpful, and quoting from this paragraph, what remains is what he's posing as a complex issue of that interplay in the terms of those three role players. And he's made a specific question, which I want to repeat to you, that says, and I'll paraphrase it. So would there be anything wrong if this committee just took the panel report and believed in the panel report and just acted on it? Because that's what he's referring to as a judicial So would you want to deal with that to navigate what he says? It's an important interplay that must be explained. I hope I summarize.
Thank you, Chair. No, thank you. That's quite correct.
Your mic is off.
Sorry, Chairperson. In my opinion, the terms of reference is quite specific. It says that the objective of the inquiry is to assess the charges contained in the motion in order to determine whether the public protector is incompetent or has misconducted herself. So the inquiry, this committee is required to assess the nature of the charges. Based on that notice of motion, how you do so would then be through a variety of measures. You'd have regard to the panel report, but you'd have regard to the court cases, but you'd want to assess, as I understood it, through witnesses who would be able to speak to the issue of the charges of incompetence and misconduct. Provided that you are able to have witnesses come before this committee, which would be able to give testimony to either substantiate or negate these charges, this committee, if the committee had availed itself of such an opportunity, it would have concluded and completed its work in a proper manner.
Okay. All right. Thank you, Mr. Ibrahim. I think let's do it like this. I'm going to ask you, because it's not going to work what's happening now. I'm going to ask you specific questions and lead you, and then you can, if you want to explain, explain, but if you want, if you agree, agree, if you disagree, disagree. You agree that the public protector accounts only and specifically to the National Assembly?
That's correct.
Yes. And you agree that that is something that is constitutionally entrenched in order to ensure the independence of the public protector?
That is correct, yes.
So that the public protector, as the name suggests, accounts almost directly to the public.
Yeah.
Because the National Assembly is the only body and the only arm of government that represents all of us as citizens, the public.
That's correct.
Yeah. In theory, the public protector would account to the 60 million people, but that's impractical. Those 60 million people have chosen 400 of their own to represent them every 5 years, correct?
That's correct, yes.
Now, those 400 people who are theoretically representing the public are entrusted constitutionally with the job of holding the public protector accountable. Okay?
That's correct, yes.
Now, I'm saying, amidst all that, the drafters of the Constitution saw it fit that there should be some role played by the executive, particularly in terms of Section 194(3)(a), the suspending clause. Understand? Okay. You seem hesitant. The president is a member of the executive, all right? Yes. And the president is one of the persons to be held accountable by the public protector. Correct? If you know the total record.
That's correct, yes.
Yes. And actually, in terms of the EFF Nkandla judgment, the president is the most powerful of the people to be held accountable by the public protector.
That's correct, yes.
And he or she may visit he or she with what Justice Mogoeng called an unfriendly response to an investigation, for example.
That's correct, yes.
Right. Now, I'm saying to you that is remember, there is no rigid model of separation of powers because these things interact in one way or the other. So this is one of the sections where, if you like, that interplay is constitutionally allowed. That the president will only suspend once the National Assembly Committee starts its proceedings and so on and so on. Okay, so I'm saying that is something to be navigated. It can be avoided because it's constitutionally entrenched. The question I'm posing to you against that background is a simpler one. I'm saying, let me do it like this again so that I can lead you. Otherwise, we have a long debate. Given that complexity, would you agree that it would be undesirable for Parliament, which has this responsibility, simply to be a conveyor belt that takes findings of the judiciary, put them in the conveyor belt, and they come out of the other side of the conveyor belt as the work of Parliament? In other words, to impeach directly by taking work which was done by a separate branch of the state, thereby, and I don't mean literally, almost having a situation where it is the judiciary's decision that impeaches the person if there's nothing that's going to happen in between. In other words, if it's a literal, you know what a conveyor belt is. If you just put something and you just convey it to the other level, you don't do anything, you don't manufacture anything in between. Would that, in your estimation, be something to be avoided, and if so, how? If you think there's no problem, that's fine. You keep on saying you don't see a problem. Then we'll move on to something else. Yeah.
I would have thought that it would be of value to the committee to avail itself of witnesses that would be able to speak to the charges.
Okay.
And that's quite a different thing. That's going beyond, that's quite aside from the judgments. I'm saying that the committee has the right and cannot ignore judgments of court, especially where they are relevant to the conduct of the public protector. Cannot ignore.
Okay.
However, the committee, I think, would be wise to also consider the evidence of witnesses that would be able to speak to the charges.
No.
So it's not just the conveyor belt.
Yeah, thank you very much. All right, then that's fine. I don't think, yeah, it's all right. Then let's go to a separate topic. I asked a question by Honorable Malham and Honorable Mola, I think, which, as I pointed out last time, you did not answer.
Okay.
And maybe you have had time to look at it. And to your credit, it's something that you alluded to almost in passing in your main evidence. And it is this. Do you accept that on the current construction of the Constitution, and I won't put it higher than this, it is conceivable that the Section 194(1) committee, which this is not the same thing as the committee envisaged in Section 194(3)(a). And I think Honorable Malem asked you this specific question. Is that committee the same as this committee? And I think Honorable Ngola asked the same thing, but from a different point of view. Firstly, do you think it's the same committee?
I have absolutely no doubt.
Good. Then, okay, then we have a problem. That's even worse if you have absolutely no doubt. All right. Now, do you agree that this committee is not a removal committee?
No, I think it is.
You think it is? Okay. No, then that's where the problem is. Because this committee doesn't think it's a removal committee correctly. The chairperson, its chairperson has said so many times, both here and in the public domain. And I agree with him. So maybe you disagree with him here. Let me maybe rephrase that. Do you accept that the job of this committee is only that which is defined in Rule 129 AD1, namely to ascertain the veracity of the charges, but it's not to remove anyone. It's only if, or once it makes a finding one way or the other. Let's call, if it says, yes, the charges are sustained, let's call that red. If it says they are not sustained, let's call that green. So as we're sitting now here, we're determining whether we should go red or green. Do you accept that at least? I'm sure you do.
Chairperson, I think we're playing with words. Let me explain why I think we are playing with words. The purpose of this committee does not have the authority either in the Constitution, legislation, or rules to remove the public protector. However, this committee has the responsibility to assess the charges contained in the motion, prepare its report in terms of its findings, and submit those findings to the National Assembly. And it is a National Assembly on the basis of a resolution of 2/3 of its members, then will issue, that will ask for the removal. The person that actually removes is the president.
All right. Can I, maybe, do you know anything about Section 177 of the Constitution? That's the one, just to assist you, the one about removal of charges. Yeah, you know something about it. Okay. Do you agree that it is the closest section, obviously with a few changes, to the one we're dealing with, 194.1? It's the closest section in the entire Constitution that, yeah, that somehow resembles what we're dealing with here. You can just have a look at it. Have you got it?
You said
177.
177,
Yeah.
yes. Yes.
Right? Yeah. Now, let me start with the similarities.
Yeah.
That section says, and I'm paraphrasing, so 177.1 is like almost the same as 194.1. Okay? A judge, put in brackets, a public protector, shall be removed only, and there's a very important word there which also gets neglected, only if A, there is a finding by a committee, the charges differ simply from the word gross. If it's a judge, it's gross misconduct. If it's a public protector, it's misconduct, but that's not important. And two-thirds vote. Okay, almost a mirror image, right?
Yeah.
Yeah. Now we know, because that has already happened many times, unlike this, which is a novel situation. Yeah. That there is a process, what I call the red-green process, which takes place until there's a finding. Once the bright light zone is reached of a finding of gross incompetence, read here, incompetence or misconduct, then you get into what you call a removal process. You cannot get into a removal process of a judge before that determination is made. Do you agree?
Yes.
Thank you. Now, that if that is so, do you also agree, therefore, that logically that should be the same as in the case of a head of a Chapter 9 institution?
Chairperson, my view is this. According to 194.1, all we are required to do is that, having set out the rules which would define really the nature of the charges or the misconduct, incapacity, or incompetence, set out the process, then establish a committee in terms of 194.1b, and task it with the responsibility of verifying and assessing the charges. The committee would then go about gathering evidence to support or otherwise deal with those charges, then table its report. It is a National Assembly by a resolution that will then vote as to whether that removal takes place or not. That is my understanding of it.
Yeah. All right. Okay.
Now, in the instance of the judges, you'd have the Judicial Service Commission making a finding
Yes.
in that instance, and then the National Assembly calling for the judge to be removed by a resolution.
Yeah, that's fine. Okay. I give up. All right. Let's try something else. You know, I'm sure, I hope, about the what has been described in the Nkandla case and in the state of capture case as the very wide powers of the public protector. And in the Home Affairs, Public Protector versus Home Affairs case, I don't want to misquote the court, but it's basically said that the powers of the public protector are almost limitless. Obviously, nothing is limitless in life. But, and I'll get it was the judge, there was Judge Plaskett, who said that the powers are so wide that they are almost limitless. Now, given that, do you, and I think in your report, you've also referred to the Mail and Guardian case, which makes the same point. Do you accept that the public protector has the discretion in the context of those wide powers to widen or narrow a complaint or the investigation? In other words, I can go to the public protector and say, they stole my pen and my glasses and my shirt and my this and the other. And then the public protector has the scope within the wide powers to just investigate the glasses, or to say, no, I'm actually going to investigate the glasses and the shoes, which you didn't mention in your complaint, if you get what I'm saying.
Chairperson, I said in my report, I'm just trying to look for the relevant paragraph because it'll be very clear from that, that the public protector may not expend. Here it is. In paragraph 68.4 of my report, it says a public protector should not expend an investigation without lawful justification. Right? And the reference there is to the case dealing with the public protector versus the press and dealing with the executive code. Right? The relevant paragraph there is paragraph 65 and then 93 to 96. So it states very specifically that the public protector should not expend an investigation without lawful justification. I have not found the issue of limiting an investigation. I have not found any guidance from the jurisprudence on that. But my argument would be as follows, is that the public protector could limit an investigation provided there was legal justification and provided that it was a bona fide limitation.
Okay.
So, for example, if there were a limitation of that power, of that investigation, it could, even an expansion of that investigation, because that expansion or limitation would involve intention, it would then, provided that it was not based on a lawful justification or bona fide, it could in fact be misconduct.
Mr. Hassan.
That is my answer to
Please,
what you're
no,
saying.
it's not. You think that you are a witness for the prosecution. You are supposed to be an expert. Well, you said you're not an expert, but you're supposed to be somewhat assisting the process. Don't bet for any side, okay? The issue I'm asking you is very simple. It's a yes or no answer. And in a way you've answered it, but you don't have to add misconduct. If you want to talk about misconduct, I'm asking the questions that we'll talk about that. I've asked you a simple question and I won't repeat it because I think you've answered it, which is that the public protector has wide powers to either expand or limit an investigation, and you and I seem to agree on that, correct?
Yeah.
Correct?
The public protector would be allowed to limit an investigation provided that. So it's not an unfettered right.
Yes. Sir, please just answer my questions.
I suppose Advocate Mbofu, Advocate Bauer.
Last week, Mr. Advocate Mpofu referred to us as the prosecution. He's now made a suggestion that the witness is batting for the prosecution. The inference again being that we appear to be prosecuting. Now, either Mr. Mpofu must clarify if that's what he's saying, or whether he's just saying it in a general sense.
Well, no, I'm not saying it in a general sense. I'm saying it in the sense that you have misinterpreted. I didn't say what you say I said. I said that he must not, I didn't say, I said he must not behave as a witness for the prosecution. That's all.
Only thing I'm asking you, Mr. Mpofu, is to clarify that you're not referring to the evidence leaders when you say that.
No, I'm not. I'm talking to the witness. Chair, please protect me. Maybe you heard what I said. If Malena Trent didn't.
Okay. No, that's I had him differently, Advocate Bauer. So proceed, Advocate Mpofu.
Thank you.
Switch on your mic, Ms. Hassan.
Yes, rather keep it on, yeah. Sir, I'm begging you. I'm simply asking you so that you can assist the committee, not to assist me or the public protector or anybody, okay? Everyone agrees, this is the first time our country has moved this far in a process of this nature, okay? It's a very complex process, contrary to what some people believe. And for that, it was important to call a witness like you. As you know, you were the very first witness. Just so happened, because you can't plan things in life exactly, that you now come after some witnesses. But the idea was to call you so that you can scope for us what we need to do. Okay, that's all that's needed from you. Don't get involved. Okay, so I'm saying to you, you and I seem to agree that the wide or quote unquote limitless powers of the public protector would generally enable her to widen or narrow a complaint. Okay, agreed?
Yes.
Yes, subject. Before you jump in, yeah. Subject to the qualification which you put in, which is true. Namely, obviously, she can't just wake up one day and I give a shopping list of complaints and say, nah, I like number 2 and number 8.
Good.
Okay. So it must be done within legal bounds. That should be obvious. Okay.
Yeah.
So wide are those powers that in terms of Section 6 of the Public Protector Act, she even has own initiation powers. In other words, she can take my complaint, she can narrow it, or she can widen it, or she doesn't even have to wait for my complaint. She can just construct one of her own. That's how wide her powers are. Agreed?
That is correct.
Yes. Now, and the only point I really want from you to assist this body with is the following, and you tell me if you agree or you don't agree. Even those wide powers, it is of no use and meaningless to accuse the public protector of having narrowed or widened a particular complaint, because she's empowered to do that. The only issue that we can inquire into is whether in a particular instance where she has either widened or narrowed, there were what you've now described as legal grounds to do so. But to simply say you narrowed it, that's like saying you were breathing. There's nothing, that's exactly what she's entitled to do. The real inquiry must be in a particular case where she has narrowed were there legal grounds, yes or no? Then of course we deal with it and so on. Would you agree with that general summation?
Yes, I think I would agree with the argument that provided. It was with legal justification.
Yeah.
And without any mala fides.
Yeah, thank you.
Chairperson, may I just be very clear, since, and I didn't want to disturb the train of thought of Advocate Mpofu. Let me say very clearly here that I'm not here betting for any side. Neither am I associated with whatever narratives that maybe have been referred to. I'm not paid to be here. I've been asked to be here, and it is out of public service duty that I'm here. I'm not inclined to support or oppose any particular if they were competing views. So I want to be very clear that please do not associate me with any of what you're suggesting. I'm not betting for any side.
Okay, so all right. To make that easier for us to grasp and accept, then don't refer to misconduct until somebody mentions that. Okay, because the overzeal to talk about misconduct may give the wrong impression. Okay, now.
Except that that's in the motion.
What?
Misconduct and.
No, it is, but it's not in my question. We can't do anything that's in the motion.
You need not to know. All right.
He must answer my questions for now. Yeah. The motion we will deal with.
That's fine.
Chairperson.
Thank you.
Right. Now. Okay, let's leave that for now. Other area where, okay, let me explain, by the way, why I'm doing this. We ourselves, when it's our turn to bring evidence, intend to bring expert evidence, quite extensive, both local and international, because contrary to what you said the last time, there is expertise in this area. It might not, well, even in this country there is, but the idea of ombud is older than all of us. So that these things are not, they might be new to us as a young democracy, but there's expertise out there. But anyway, that's an aside there. So I'm testing some of the themes that will be coming from our experts with you, just so that we can situate, the committee can then say, okay, well, there was a different view that was expressed on this, and obviously it will have to choose. Right, now, do you agree or not agree that another area that will need to be navigated by a committee of this nature is another dichotomy is between the investigative role of the public protector as opposed to what some people see as an adjudicative role. I hope you know what I mean by those two. Yeah. That I think it was Mlambo, Judge President Mlambo in the state of capture case, that who expressed it in crisp terms that the public protector is not an adjudicator, but an investigator. And I don't want to give you a long background. I was in that case, I argued that point on the following basis, and you can agree or disagree with it. As you might know, what happened there is that the public protector had issued remedial action for the appointment of a commission of inquiry, but had decreed that it must not be appointed by the president, contrary to what the Constitution says in Section 84. Okay, because the president was conflicted. All right. Now, our opponents said, no way, it's not possible. The Constitution is very clear. Here it is. It says the president, every commission will be appointed by the president. Right? And we said, which is what I'm trying to say to you, no. The powers of the public protector are so expansive that it should be permissible, particularly because it's an investigation rather than an adjudication. Because an investigation can take you anywhere. I could be investigating this person, and then it leads me to that person, to that person, to that person. You never know where it's going to take you. And the court agreed with us, among other things, on the basis of this distinction of investigative powers versus adjudicative powers. Firstly, do you think that's an important distinction which will need to be unpacked for this committee before it makes its decision? If so, how do you link it to this question of that it even widens the powers even further? In other words, okay, no, let me not make that illustration. First question, do you appreciate that distinction? Or do you understand it?
I think I understand it.
Yeah, okay. And do you agree that it, as the court said in that case, widens the powers of the public protector even further? In other words, she could have had wide adjudicative powers, but now she has wide investigation powers, which are even wider. Agreed?
Yes, of course, it would be subject to legal justification.
No, fair enough, yes.
That's
But
right.
okay, I'm making a simpler point, Mr. Ibrahim. In an adjudicative process, you are literally handcuffed or hamstrung by the pleadings, okay? So it doesn't matter what you think. If I have a dispute against the chairperson, which I would never have, yeah,
It's just an example.
just an example, yeah. Then in an adjudicative process, it will be confined to that dispute. The judge might have ideas about that there might be other disputes like this next week, but it's tough luck. Yeah. But in an investigative process, you don't have those kinds of restrictions. You, as I say, it can take you anywhere. You never know. You might think you're investigating a dispute between myself and the chairperson and end up investigating the entire parliament. Do you understand that distinction? Or rather, do you think it applies to what we're busy with here?
Chairperson, I think it is in a Mail and Guardian case which are required of the public protector to have an open mind to see where an investigation would lead, to investigate the matter, and if it raised more issues, then to pursue those issues. So an open mind is a requirement of the public protector. And that has been established in our courts.
Yeah, okay. I think you're conflating two issues. The open mind, yeah, I agree with you. That's par for the course. I'm exploring something else, but again, I think you've answered it in your own way, which is that the real gist of what was being said in Mail and Guardian, which is the first part of what you said, namely that unlike in an adjudicative process, an investigation can take you to places that you haven't even imagined when you started. So at least we agree on that part.
Yeah.
Okay, good. Now, okay, we've also dealt with this in a way, but again, I just want to put to you as a proposition. There are 3 sections of the Constitution which deal with impeachment, principally. There are others, but premiers and so on. But the main 3 sections are Section 89, which deals with the impeachment of a president.
Yes.
Section 177, which deals with the impeachment of a judge. And Section 194, which deals with the impeachment of a head of a Chapter 9 institution. Okay. One of the anomalies, let me call it that, in this process, and again, it's a peculiarly South African thing, is the fact that the rules that govern this process were literally copied, for lack of a better word. The DA took the rules. There were rules that were developed as a result of the outcome of the case of EFF impeachment, again, which we argued, the one that you and I were debating unsuccessfully about what is the meaning of predetermination. I don't want to go back there. But as a result of that case, rules were developed by this parliament. And the DA took those rules, I suppose, if you take a neutral view to it, so as not to reinvent the wheel, and just change them here and there cosmetically. But it's essentially the same rules, okay? Now, the problem with that, and I'm posing it to you, again, you agree with me or not agree, is that the Section 89 of the Constitution is not really like Section 194 of the Constitution. It is Section 177, as I said to you, which is more akin to Section 194. So as a result, it might have been a mistake, or it will be resolved by other generations maybe. But it might be a mistake to simply transplant rules which are meant for the impeachment of a president for this kind of thing we're dealing with here. And it goes back to this question of suspension and the other intersection I was talking about. One of the most glaring differences between the two is that a president cannot be suspended. If you may or may not know this, yeah. Whereas a judge and the head of an sorry, Chair, can I just finish the question? I see there's a hand. But can I just finish? Yes, I'll just finish. Maybe Honorable Malam can speak before you answer. But let me just finish. The point I'm making is, whether you agree with me or not with that summation, that particularly because a president can kill, I'm exaggerating, 1,000 people, but nothing can be done to them. They cannot be suspended until the second leg of what you and I have described happens, which is just to go to Parliament and get a 2/3 majority. Do you agree or don't you agree that there is that, what I call the misalignment of the impeachment processes?
No, I don't agree.
Okay, all right. Thanks.
Honorable Myla.
Chairperson, thank you. And I didn't want to interrupt Advocate Mpofu, so I apologize for any
no problem.
disturbance. Chair, my concern is this, that what Advocate Mpofu is addressing now relates to the rules of Parliament and the processes that have been set up. Now, as a committee, we have no mandate, no authority whatsoever to make any finding or to change any of the rules of Parliament. That would have to go through the Rules Committee and be adopted by the House. And so I don't quite, and again, it might be me, but I don't quite get the relevance of this line of questioning to the mandate of this committee, namely to determine the veracity of the charges. And I would really welcome some help here, because we again seem to be going down a rabbit hole that doesn't address our core function. Thank you, Chair.
All right, thank you, Honorable Mayham. I'm following that. I'm waiting for the responses from Mr. Hassan, and before. So you think that he's asking a question after hearing the response?
I think he's asking me.
No. Oh. No, I'm watching that space, Honorable Mylam, because I think I will intervene when I need to do that. But I'm allowing all the clarifications and the interaction between Advocate Mpofu and Mr. Hassan. Otherwise, you're correct in what you've put on the table.
Yes, for what it's worth, I think I'm happy to respond to Honorable Mylam. I think he's raising an important issue. Yes, thank you. That's all I was saying. Yeah, I don't feel that he's interrupting me. Yeah. It's very important, the question he's raising. In my view, with respect, my humble view, it's impossible. There's no committee of the National Assembly, or actually no constitutional structure in this country, which can just operate in some bubble of its own. It has to operate within the constitutional framework that makes it, that constitutes it. That's what a constitutional democracy means. So there's no world in which the committee can just say, look, we've got a mandate, we've been assigned this, there are charges, and we're just going to do this, without being mindful of the constitutional context. I thought that's what this kind of witness was here for. Not to talk about, this is a kind of witness who might not even have read the charges. He doesn't care about that. His evidence, as I understand it, is to situate the whole business within a particular constitutional context. So it's not going to help if we're going to say, well, let's just stick to the rules, you know, and move and get on with it. That's fine. We can do that too, but then we mustn't call people like this. because their function is really to go beyond and try and assist us in this novel world that we're entering, uncharted waters and all that. Yeah.
I need to understand this. Advocate Mpofu, thank you. I understand what you're saying, but my concern is that the witness's role is to contextualize the functions, powers, and role of the public protector, not the functions, powers, and role of this committee. And those are two very different things. So for the purposes of what we're doing here today and over the next couple of weeks, what the witness is here for is to tell us, here's what the public protector is authorized by the Constitution to do. Here's the scope of her powers. Here's where it is situated. Contextualize that rather than try and contextualize this committee. And I think that's the rabbit hole that I'm concerned we're going down.
Okay, thank you, Honorable Milam. I'm just going to quickly respond, and then I'll ask you to proceed with the witness in the sense that the one part of what you say is correct, Honorable Milam, which is what Mr. Hassan would have presented here, but it did not end there because he created a context because the role of this committee and the role of the public protector is contextualized, which is what he did. Even today, he started with a prelude that talked about the Constitution, the rules, and so on. So I want us to just a little bit of patience in that regard to absorb all of those kind of issues. So, and Advocate Mpofu, you
Yes,
the platform so that we don't eat much into your time.
No, thank you, Chair.
as
I
heading
appreciate
towards
it.
5
Yes,
o'clock.
thank you, Chair. We'll maybe Honorable Malham and I will resolve that issue even through another witness. Yeah. Right. You also made a statement the last time you were here about that the section 194, you said, is to protect the office and not the person, right? Now, I want to again explore in the same way this statement, which, as you might guess, I don't agree with. But, and as I say, we'll bring witnesses who will contextualize it. But in fairness to you, I need to put this to you. Have you read the certification judgment of the Constitutional Court?
Yes, I did.
Right. And just so that we're clear, I have no problem with accepting upfront the fact that the overall intention of any removal process is obviously to protect something like an institution. That's not rocket science. If it's a school, they will say we're firing this teacher because the school must be protected. If it's some pick and pay or whatever, the same. Okay, so don't get me wrong, I accept that. But I'm saying what must not be lost sight of, if you've read the certification judgment, is that at the same time, there is the value of independence, which must be protected equally. In other words, it doesn't help to just elevate the value of accountability and sacrifice other values. There are values of human dignity. There are values of Ubuntu. There are values, there are all sorts of values, rule of law and so on. Now, in that mix, would you accept at a bare minimum that one of the purposes of Section 194 is to protect the person?
No,
No, okay,
it is to protect the office.
only.
May I explain?
No, it's fine.
Chairperson? I think it's actually quite an important
fine.
point that is
Go
being
ahead.
made, and a lot turns on it. I want to refer you to, and it's in my notes, it's in paragraph 89.
Yeah.
And the reference is to the public protector versus South African Revenue Services. The quotation is a very useful one for this committee. It's at paragraph 44. And it says, axiomatically, the public protector's office is more important than the incumbent. The impact of certain types of conduct that shake its operations at the foundations may outlive the terms of office of a number of incumbents. You weaken that office, you weaken our constitutional democracy. Its potency, its attractiveness to those it must serve, its effectiveness to deliver on the constitutional mandate must be preserved for posterity. So what in effect is the case is that the office is far more important than the incumbent. In fact, the office needs to be protected against the conduct of the incumbent, only because of the possibility of long-term impact in terms of what is being said here. And I think it's quite an important statement that is being made.
Okay, thank you, Mr. Hassan. I think, again, you don't understand what I'm saying. That case, I argued that case, okay? That's another case which I argued in the Constitutional Court. And we succeeded in that case to illustrate the following point, not the point that you seem to be making. That statement was made by Madlanga J. And in a completely different context. The paragraph preceding the one that you are saying talks about the phrase that Madlanga J used was the disturbing frequency with which our courts were singling out the public protector for personnel costs, okay? Because I had argued in that case for the first time that the public protector was that it was being made fashionable to visit her with particular costs. Just for free, I'll tell you, the judge in that case had literally, every paragraph had it was like Mr. Samuel, it had some insult and, adjective or whatever about the public protector. And the court found that each of those was completely unwarranted. There was simply no basis for it. And it was just, momentum that the public protector must just be disparaged, okay? And the court said the following. It said here in the Constitutional Court, we have had 4 cases where the public protector has been visited with personnel costs. And it said, we've rejected all except one of them. And that was the CX, what we now know here in this room as the CX case, okay? And it then said, we're cautioning the courts to not to think that the public protector is fair game. That's actually the words that were used by the Constitutional Court. It's fair game, just to be visited by those costs. And then he said, because even if you might, well, okay, that's my editing. You might not like the incumbent, but the office is more important, because if you, by targeting the incumbent, advertently or inadvertently weaken the office, then you're weakening the institution. So that statement you're making was put in a completely different, it should not be taken out of context to mean that the office is more important than the person. Actually, in that case, it was the exact opposite, because we were talking about the person, but the judge made that statement. The point I'm simply making to you, Mr. Hassan, and I thought I was making it easy, Mr. Ibrahim, sorry. I thought I was making it easy for you when I was started by the concession that the office is important, so that you don't think we have any difference there. The only point I'm making to you is to say, in a constitutional state, in protecting the office or whatever, the office is just a building of bricks or whatever. In protecting the office, we should be mindful to ensure that the human rights of the human being are protected, 1. 2, because of the nature of this particular office, you must also protect its independence. And to that extent, Section 194 is a protective measure. Agree or don't agree?
I hear you.
No, I know you hear me.
I hear you and understand you.
But you don't agree.
I'm not sure where you're going with that argument.
No, I'm not going. I'm just asking you a very simple question. Do you agree that Section 194 is a protective measure? Yes or no? I'm not going anywhere.
I'm not sure if I would regard it as a protective measure.
Okay. Now, let me assist you. That's why I started by asking you whether you've read the certification case. Do you know that as a result of the certification, directly as a result, or let me put it this way, when our constitution was passed, the removal yardstick for the public protector was 50% plus 1.
Yes.
Right?
Yes.
The certification case said no.
Correct.
Because this person will be investigating powerful people in the executive and will be vulnerable to victimization, we must lift the yardstick to 2/3. Would you agree that that was a protective measure?
It was a measure to ensure and secure the independence of the public protector.
Good. Thank you. We're getting somewhere now. That's what I was saying to you, but I say you didn't know where I was going. Yeah. So in the first instance, it was to protect the independence of the institution.
Yeah.
Granted. Yeah. But do you also agree that in the second instance, it was therefore a measure to also protect the incumbent from victimization, from possible victimization, theoretical, potential victimization?
As would be the protection against all public officials, in the sense that, you know, they should be protected against victimization.
Yes.
I mean, I have no difficulty with arguing that the public protector conceptually, in terms of the law, has to be protected. Yes.
Okay.
No question about it.
Good. Take that as a yes. All right. Now, if we then it looks we have traveled together properly. Within that, what we've now, you and I have agreed, would you agree that it is to overstate the case to say that Section 194 is to protect the office and not the person? The correct statement is that Section 194 is to protect the institution, yes, the independence of the institution, yes, and the incumbent. Would you agree? And that is not just the public protector, by the way, it's the Auditor General. Yeah. That's also a crucial thing, because of all the Chapter 9 institutions, the certification case singled out the AG and the PP for this extra protection. Agreed?
Yes.
Good. So, okay, I don't want to mislead you into agreeing with two propositions, and so I'm breaking it down. We've agreed on the second one. The real issue I was conversing with you is that would you agree, therefore, that your statement needs to be altered, tempered, amended, whatever you call it, from this rigid, the way you put it, Section 194 is to protect the office and not the person. Now that's clear, that's black and white. And I'm saying it's much grayer than that. And that that section, yes, has got measures to protect the institution, obviously, just as the removal of a judge is to protect the judiciary. Nobody can argue about that. But the extra purpose or purposes are to protect the independence and the incumbent as a human being, as a person, as a bearer of human rights in their own right. Correct?
I'm afraid I don't read what you are reading into it.
Okay.
I don't agree with that.
All right. I give up again. Yeah, that's fine. I thought we were getting somewhere. All right. Okay. No, sorry. No, oh yes, no. Yeah, no, can I? It's back it up. Do you think that the EFF Nkandla case was a major turning point in my view? You don't have to go that far. We wouldn't be sitting here if that case had not happened. But I don't want you don't have to agree with that necessarily. But do you think that it was a major turning point in the evolution of this constitutional area?
I'm not sure what you mean by that, so I'm not sure if I can agree with that.
Which part do you
I don't
understand?
understand what
Turning
what
point. You
you're
don't know what a turning point is.
saying. I know what a turning point is,
Okay.
but turning point for what? Turning point from what to what?
Okay. Prior to the EFF Nkandla case, it was believed and even widely accepted.
Just as you proceed, just a reminder, as agreed, that we'll be wrapping up at 5.
Yes.
Thank you.
Thank you, Chair. Prior to the Nkandla case, do you agree that there was not quite consensus, but there was acceptance that the powers, the remedial powers of the public protector were recommendations? In fact, I remember in this very parliament, there was a hot debate around the Nkandla issue, where the chair of the committee, Dr. Mutseha, kept on reminding everyone that these were mere recommendations. But as from that point, and actually there was a case of the DA that had just come from the, actually what happened is that the DA joined our case because this very point was raised in a DA case that was in the SCA. And so it was convenient for it to be, those were the days when the DA was on the side of those who wanted to ensure that kind of accountability. But that's a story for another day. But in that case, it was then determined for the first time that remedial powers of a public protector are binding. Almost, and this was, well, for all constitutionalists, this was a revolutionary thing, but you don't seem to think it was a turning point. And that would then elevate the powers of the public protector, not quite to be like a court order, but almost there. In other words, you could only not comply with powers of the public protector if they have been set aside. Otherwise, you can go to jail, kind of. And you don't regard that as a turning point in the area we're discussing?
I would describe it somewhat differently. I think what has been happening is that when it comes to the question of remedial powers, it's quite a novel constitutional instrument and an authority or a power given to the public protector. What has happened in our law is that it has been evolving, and it's been going through a journey through all the jurisprudence. And so it was left for clarification as to what the authority and the power of a remedial action, a declaration of the remedial action would be. And so what we have had in our jurisprudence is an evolution of really defining the limits, the boundaries, and really the extent of it all. So yes, remedial powers have been regarded as something that it's imperative. It's a requirement. It's binding, and the only way to deal with it, to challenge it, is by a judicial review.
Yes. No. Believe me, I was there.
Yeah.
So you don't have to summarize the case for me. I'm saying, and that's not what I'm asking you. I'm asking you whether that which you have just described should be described as a major momentous turning point. And let me maybe assist you this way. Before that, I could have the public protector making a finding against me that I've done this or the other. And quite frankly, I'll take it and throw it in the dustbin. Then so what?
Yeah.
So in the stakes of accountability, for the first time, I could not do that. I now either had to go to court and challenge it or face the consequences. And if that's something like that, why do you have a difficulty with accepting that that was a major turning point?
I think you are ascribing various adjectives to what was.
Okay, let's forget major.
Forget
was it
all
a turning point?
I think it's for the first time that the courts had clearly declared really what the authority was.
All right, I get up. Okay, that's fine. I don't know why you would have a problem. Well, every scholar that I know on this area accepts that this was what in Afrikaans we call it keerpunt. But there you are, Mr. Ibrahim. If you don't think so, you don't think so. Now, and this is the last topic that I will explore with you. Chair, if you can give me just a few extra minutes. Because unfortunately, I've not even been able to cover the ground because Mr. Ibrahim is just not playing ball. Let me ask you this. Okay, Chair, sorry, it's not the last point, the 1.5. Let me start with the half. The half is I call it half because it's, as I said, firstly, I promised you that I'm not going to go back to it, but I was not under oath. The second part is that there's a completely different issue. Remember the debate you and I had about the nature and purpose of the inquiry vis-a-vis the whole thing about predetermination. Yeah, okay. Now, if you go to paragraph 207 of the EFF impeachment case.
Yeah,
is the one that, yeah. You remember, I think around about 178 or 179, that's where they started to talk about institutional predetermination.
I don't know. I'm trying to look for the authority. I don't have the document immediately.
Okay, fine. I'll read it out. I'll read it out to you.
Please.
Or can be put up. It says, and it also touches on this thing about the removal committee and so on. The acting speaker was Mr. Tsenodi, whom I rate very highly on this area. He's one of the few people in this parliament who understands, at least by his actions, who seems to understand fortunately, he just was the acting speaker when we brought this to court here. And this is, it says, the acting speaker agrees with the applicants, that would be us, that and the DA, that a removal of the president must be preceded by a finding, right, by the assembly that the president has committed a serious misconduct or serious violation of the constitution or the law. This view of the parties accords with the language and requirements of section 891. If the president is removed, in terms of 891A, B, she may forfeit the benefit. That is why the acting speaker describes those provisions requiring proof of wrongdoing on the part of the president. Now, because of time, I will not read this with an earlier paragraph. I think it's paragraph 137, where the same judge said that the reason why we have to go through all this rigmarole is because the impeachment is by definition punitive to the person. But we've explored that. And we've disagreed on it. But would you agree at the least that this seems to suggest that a removal process properly defined can only happen post the finding of a committee such as this one?
Yes, that's correct. The committee must be as per 194.1.
Yeah, thank you. That's fine. Then the next question is going to be quite longish because I have to keep to my promise that it's the last one. Or rather, it's the last area I want us to explore. And it goes back, Mr. Ibrahim, to this question about the role of the judiciary in a process like this, which I think any constitutional scholar would agree should be, let's say, avoided. I mean, any notion that an office bearer is being impeached by the judiciary should be avoided because of the separation of powers. You would agree?
Sure.
Yes. Now, what are we to do given that understanding with a factual situation where there's a court judgment? We know that it's binding in law, but as you and I should know, you don't get bound by the facts. The rule stare decisis doesn't apply to the facts because no facts are ever the same anyway. But what is to be done about a situation where a judgment, let's say, says public protector is totally inept or whatever, must be done away with because of this factual situation. She took this pen, she put it here instead of putting here, and so on and so on. And then here, we come here and have a situation, we actually find that no, the public protector did not even touch the pen. And there are two schools of thought seemingly here, at least. One says, well, you just, a court is a court, it's binding, goodbye. Or you say, well, on these facts, which is why we have an inquiry, and I think in fairness to you, you've said that. On these facts, before us as a committee, this did not happen, and therefore that finding is not going to influence us, which is the theory that we contend. And I'll make one example because we don't have time. There's a judgment already here. We have a judgment where it was said that the public protector was malafide and all sorts of things, because in her report, it had been explicitly stated that she had not seen a particular report. And that's just wrong. It's not there. We asked the witness who was sitting where you are, theoretically, where is it? And he couldn't find it. It's not there. It's just simply not there. Assume for a minute that I'm correct. It's not there, either explicitly or otherwise. Yeah. Now, should we then say, no, we don't care? Even though this as a committee, we all agree that it's not there. But because that judge said, as a result of that non-fact, she is malafide. Can you see where I'm going with this? So I'm saying, what should be done in those? There are many other examples. In the CX, the same thing. The judge said, she said something about vulnerability. A witness, Mr. Kekana, says, oh, I was just asking myself something. And then it was heaped on her and she was condemned. But I don't want, we'll do that as we proceed, yeah. But what should we do in those kinds of situations?
Chairperson, the issue is quite a fundamental one. We've just been through the issue of the remedial action issued by a public protector and the strength and the importance of it. We're now talking about a judgment of court, and we are suggesting somewhat differently. The moment a country has less regard for the judgments of its courts, the constitutional democracy, if that's what it is in trouble. So we should be cautious of not treating judgments of a court with the seriousness that I believe it deserves in terms of the concept of a rule of law.
Okay, thank you. So that answer therefore suggests—
Can we wrap up?
Yes, I promise, Chair. Yeah. So no, I think then we're clear on the value or lack thereof of your testimony. But just to be fair to you, how I summarize what you're saying, therefore, is that what we call in the township ketile. Once the court has started, if it says the sun sets from the west, then the sun sets from the west. In other words, this thing called an inquiry, to inquire is to inquire, Mr. Ibrahim. So what then would be the point? Then we don't need an inquiry because the judges have told us, and the rule of law says that all the kind of emotional statement that you've just made now, which is generally true, the day we deviate from courts, whatever. But that's not what I'm asking you to do. I'm saying there's a constitutional paradox, and if you don't see it, you don't see it, between that which you're saying, which is correct, and the duty to inquire into the facts. If you don't see the paradox, then we stop here. But if you see it, how should it be navigated?
I'm not sure where that is going. The point is, it's not whether I see it or I don't see it, it's whether I agree with it or I don't agree with it. We are talking here in a committee of parliament, the body that is required to make laws, where judicial where judgments are going in a direction which is considered to be inadequate or inappropriate, this is a place where laws are made, where corrective action can be taken. This is where these matters are dealt with. So it's not a question of calling before you are. You have two choices. Either you accept the judgments of court because that's what they are and they are there to be respected, or you develop laws which will change the laws of this country in terms of which the law will then be redefined. So it's not a question of whether I see it or I don't see it. It's a question of whether one can agree with that or not in a committee of parliament, which is here to make the laws. If there are problems with the way in which courts deal with it, then change the laws.
Okay. So in other words, we're bound by
Your
the
last word,
facts.
Advocate Mbofu.
Promise, Chair. So therefore we're bound by the facts, not just by the law. And therefore there's no need to inquire into the facts. That's really what you're saying.
No, Chairperson, that's absolutely incorrect.
Yeah.
We're not bound by facts. This is an institution of parliament, and parliament has the ultimate authority to make laws provided that it is consistent with the constitution. That's all it requires. And parliament is entitled to make whatever laws it intends to, provided it is consistent with its constitution. And so if judgments of court are going in a direction which the representatives, the voice of the people feels different, then it is up to parliament to decide differently. So it's not a question of whether I see what you're saying or not.
Yeah.
I don't quite agree with the approach that you're adopting.
No, that's fine, Chair. It's a Friday. Okay, I think I'll end it with my refrain. I give up. Thank you, Chairperson.
Thank you, Advocate Mbofu. Thank you, Mr. Hassan Ibrahim, for your time. Just to indicate to you as we do our work and continue to do our work, at whatever point that members would want to enrich and interaction with yourself, where possible, that you'll be able to make yourself available. So thank you for your time and having come back today. Any last word you want to say?
Chairman, it's been an absolute pleasure. It's not the easiest of exercises to be in, but I'm grateful for the invitation to participate. It's been at my own instance and in the sense that I've given up my time and effort to actually be here because I appreciate the value and the importance of what you are undertaking. And I'm grateful for this opportunity. Thank you very much.
Yeah, just before we stop, that's my last comment I want to make before we close the meeting. Advocate Mbofu would have lifted me up as an example at some point here, an example of a chairperson who has a particular view of the nature of this committee. I thought it's important that I just clarify that and say this entire committee, including its chair, is of the same understanding of our role as clearly defined in section 194 with the big bold headings reading removal from office. That's section 194. And we have been very consistent, including in the rules. To rule 129 AD, the functions and powers of this committee reads, the committee must, when the assembly has approved the recommendations of the independent panel in terms of rule 129Z, proceed to conduct an inquiry and establish the veracity of the charges and report to the National Assembly thereon. And so you're quite correct, therefore the removal becomes a decision of the National Assembly, but it can't do that decision if this committee would not do its work. So there's symbiotic kind of relations there. I hope the matter, so the chair now is clarifying, this is where I don't know, maybe it might have gotten a little bit different, but I've been very consistent in terms of that from the rule making process up until now. So
Chair,
I hope the matter is put to rest.
No, it will be, I want to assist you. It will be put to rest in the forthcoming judgment. It was argued extensively in on
Yes.
Monday and Tuesday.
I was going to make that point that the matter would have been even canvassed at that level. So, but I thought for the sake
For
of the
now.
committee and the chair, that clarity must be put. Thank you very much to all of you. We adjourn the hearing today. We'll meet on Monday as we proceed with our work. Thank you very much. Meeting adjourned.
Thank you, Chair. Recording stopped.